Good morning, sir. Can you see and hear me?
Yes, I can. Thank you.
With your leave, may I call Duncan Atkinson Casey, please?
Of course, yeah.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Good morning, Mr. Atkinson. As you know, my name is Jason Beer and I ask questions on behalf of the inquiry. Can you give us your full name, please?
My full name is Richard Duncan Atkinson, but I answer the name of Duncan.
Thank you. You've been instructed by the inquiry as an independent expert to assist the inquiry, and this is a very high-level summary of the tasks as to the law and practice of the conduct of investigations and prosecutions by a private investigator or prosecutor between the years 2000 and 2013, and the compliance or not of the Post Office with that law and practice in some of the investigations that it undertook and the prosecutions that it initiated and pursued in those years. Is that right?
Yes.
And you have, I think, at the inquiry's request, divided your task into two parts. The first part concerns the legal framework for investigation and prosecution, both in the Post Office and more broadly, and the framework relating to the responsibilities of prosecuting authorities, investigators, charging decisions, prosecutions, expert evidence, and disclosure.
Yes.
That concerns consideration of the applicable statutory provisions, the codes of practice issued under statute, guidelines, guidance, case law, and other material from a range of sources, and then consideration of the policy documents and guidance issued by the Post Office.
Yes.
And the second part of your task is to assess how the framework that you have so outlined was in fact applied by the Post Office in specific investigations and prosecutions by reference to specific cases.
Yes. And I should say that I have moved beyond the work I had done at the time I prepared this report with a view to completing part 2, but I have not yet completed part 2.
I understand. Now, the first part of your task, that's addressed in volumes 1 and 1A of your report, is
Yes.
that right? Can we look at those, please? Volume 1 is, it'll come up on the screen for you, and I think you've got a hard copy there.
I have.
EXP 602. Thank you. Is that the first page of volume 1 of your report?
Yes, it is.
And I think it runs to 181 pages, including appendices.
I'm afraid so.
And that report addresses all issues of the part 1 task, apart from expert evidence. Is that right?
Yes.
Are the contents of this report true to the best of your knowledge and belief?
Yes.
Can we turn, please, to page 167? That's the, thank you. You should find there Appendix 1,
Yes.
which contains an expert's declaration. I'm not going to ask you to read it all out now, but if you just, if the operator can just scroll through, please. We'll see 11 paragraphs of a declaration. It goes over the page. Are the declarations that you make on those 2 pages correct?
Yes.
Thank you. Can we turn to volume 1A, please, which is EXP 603. Is this the front page of volume 1A of your report?
Yes, it is.
And I think with appendices, that is 15 pages long. Are the contents of that report true to the best of your knowledge and belief?
Yes, they are.
And do the expert witness declarations that we've just seen, the 11 declarations, apply equally to this report too?
Yes, they do.
Thank you very much. Now, I think that can come down from the screen, thank you. You are to provide the inquiry with a volume 2 report reflecting your opinion on part 2 of your instructions, and you're to return to the inquiry later this year in December to provide further oral evidence. Is
Yes,
that right?
that's right.
I think it's right, however, as you've just said, that you have now already reviewed a quantity of the material that's relevant to your volume 2 report. And has that assisted you in understanding and giving an opinion on the issues raised in the 2 reports that we're considering today?
Yes, it has.
Can I start then, please, with your background and experience? Your CV is set out in Appendix 2 to your Volume 1 report. It's at page 169 through to 171 for the transcript. But can I summarise it and tell me whether you agree or disagree? Certainly the key elements of it. You were called to the bar in 1995 and you took silk in 2015, is that right? Yes. You were Treasury Counsel between 2009 and 2022,
yes,
including a period as Senior Treasury Counsel from 2015.
Yes.
And you are a specialist criminal practitioner with elements of your practice involving both public law and public inquiry work.
Yes.
Have you regularly prosecuted for the Crown Prosecution Service?
Yes.
But also the Health and Safety Executive?
Yes.
The Serious Fraud Office, the SFO?
Yes.
And the Environment Agency?
Yes.
Have you ever been instructed by the Post Office Limited?
No.
Do you have any direct experience of private prosecutions during what I'm going to call the relevant period, which is 2000 to 2013?
Yes.
And is that as prosecuting counsel or defence counsel or both?
Both.
I think you are widely published, but amongst those publications that are significant and relevant for our purposes, are you a co-author of Blackstone's Guide to the Criminal Procedure Rules, an OUP publication?
Yes.
And also, are you a contributor to Blackstone's Criminal Practice, also by Oxford University Press?
Yes, the latter in a more up-to-date way than the former.
Thank you. I've already set out at a high level the nature of your instructions. Can we look at your Volume 1 report at page 5, please? So that's EXP 602 at page 5. Page 5, please. This sets out in slightly more detail the issues that you were asked to consider, and they were divided in broad terms between issues relating to investigations on the one hand and prosecution on the other. Is that right?
Yes, that's right.
And in relation to investigation, you were asked whether any special difficulties arise where the same body is the victim, a witness, the investigator, and the prosecutor, and if so, what should be done to ensure independence of decision-making? And you address that in your report.
Yes, I do.
You were asked to address the terms and adequacy of the Post Office's policy documents concerning the conduct of investigations. You address that in your report.
Yes.
And you were asked to consider the duties of an investigator to pursue a reasonable line of inquiry, generally, and also where a person positively asserts that they believe that the problems they'd experienced, accounting shortfalls at their Horizon terminals, might lie with the computer system.
Yes, that's right.
And then in relation to the second half, broadly, you were asked to address, under the heading of prosecutions, charging decisions, including the test that the prosecutor applied or ought to have applied, including an analysis of Post Office prosecutorial guidance and policy, and any policy decisions made in relation to prosecutions based on Horizon evidence?
Yes.
And you address that in your report. The evidence that the prosecutor reviewed when making a charging decision, or which they ought to have reviewed, the extent to which the charging decisions appear to be thorough and conscientious, the approach said to have been undertaken of charging theft and false accounting, and your attention was drawn to the decision of the Court of Appeal in Eden, in which the practice of the Post Office charging both theft and false accounting received judicial disapproval. You were asked to address how proceedings were commenced by the application for the issue of a summons in the Magistrates' Court and the existence of a duty of candour when applying for such a summons.
In relation to that, and indeed in relation to 3A, little 2, 3, and to an extent 4, what I've looked at for the purposes of this report is what there is in policy terms and in terms of wider guidance in relation to those issues. What evidence was actually reviewed, the thoroughness or otherwise of actual charging decisions and so on is a volume 2 matter rather than for now.
Yes. You were asked to, under this heading, consider thirdly disclosure, whether there was a quote, disclosure officer, as would exist in a prosecution conducted under the CPIA or equivalent, and if not, any difficulties that this created. And again, is that something of a mixed
Yes, it is.
Issue, in that in this report, or in these reports, you've considered whether there was policy relating to that issue. In your Volume 2 report, you'll address the position on the ground.
Absolutely.
Under this heading, you were asked to consider whether prosecutors reviewed the adequacy of disclosure. Again, a mixed question. In this report, you consider whether policy documents required them to.
Yes, or equip them to.
The extent, lastly, under this subheading, of the duty of cross-disclosure, i.e. where an issue arises in case A, there's a duty to give disclosure of it. In cases B, C, D, etc., you address that in this report.
To an extent, but I think that's more a question for Volume 2.
And lastly, prosecutorial practice. The practice said to have been undertaken of plea bargaining, i.e. offering no evidence on account of theft in return for a plea on account of false accounting. And lastly, the relevance of the approach taken to reliance on Horizon data to the repeal of Section 69 of the Policing Criminal Evidence Act 1984 by the Youth and Criminal Evidence Act 1999.
Yes.
I think that can come down, thank you. I think you were provided with a very large volume of material, is that right?
Yes.
And that's listed in Appendix 3 to your report. There's no need to turn it up for the transcript. It's pages 173 to 179 of the transcript. And did you yourself additionally refer to a large volume of publicly available material?
Yes. In the versions that I was able to obtain.
More of which later.
Yes.
And so in your Volume 1 and 1A reports, you cross-refer to publicly available material by way of hyperlinks that are embedded in your report,
yes.
So the reader can click through and read them, or by footnotes, yes. In your Volume 1 and 1A reports. And is all of that material listed in Appendix 3, Part 2
yes.
of your Volume 1 report? That's pages 179 to 181 for the transcript. Were you additionally provided with a quantity of material emanating from the Post Office, considering of, in broad terms, policies, guidelines and guidance?
Yes, at various stages while I was working on the report and since.
Were you provided more recently with a report commissioned by the Post Office Limited and written by Jonathan Laidlaw, King's Counsel?
Yes, I was.
And also provided with a substantial body of the material that was referred to in his report?
Yes.
I think you were assisted in the assimilation of material and the compilation of your Volume 1 and 1A reports by Catherine Brown.
Yes, I was.
A barrister in your chambers, I
yes.
think, whose CV is set out on pages 171 and 172 of your Volume 1 report, but are the opinions that you give in the report and those that you're about to give today your own?
Yes, they are.
Thank you. Can we start, please, by looking at Volume 1 of the report? So that's EXP 602. And look, please, at page 4. At paragraph 2.1, if we scroll down, please. You say, I'm asked to address the following questions in this report. An explanation of the law and practice of the conduct of investigations and prosecutions by a private investigator stroke prosecutor between 2000 and 2013, focusing on the application or non-application, as the case may be, of, and then a series of statutes and other instruments.
Yes.
Would you agree that a private prosecutor, sorry, a private prosecution is a prosecution started by a private individual or a private entity which is not acting on behalf of the police or some other prosecuting authority?
Certainly not acting on behalf of the police. I think it slightly depends on your definition of the authority as to whether it is a private prosecution truly described or not.
Would a way of describing a prosecuting authority, in inverted commas, include an entity which has a statutory power to prosecute?
Yes.
But it could extend beyond that?
Yes.
So it includes but not limited
Absolutely.
to such an entity. So would the classic example of a public prosecutor be the Crown Prosecution Service, the CPS?
Yes.
And in that circumstances, it acts on behalf of, or it prosecutes for, the police service?
Amongst others, by reference to the Prosecution of Offences Act, which sets out its statutory position.
And there are a large number of other bodies that it prosecutes for?
Yes, which are listed in, I think, Section 3 of that Act.
You identify in paragraph 34 of your report, there's no need to turn it up, other entities with a statutory power to prosecute during the relevant period covered by your report, those 13 or so years, including the SFO, the Serious Fraud Office, or the director of the SFO, the Department of Work and Pensions, the Health and Safety Executive, and the Environment Agency. Would you agree that those entities are public rather than private prosecutors?
They're in some respects, something of a hybrid, certainly on the basis of the approach that the Court of Appeal and the House of Lords have taken to it. Sometimes they have treated them as being public and sometimes private, but with a statutory basis for their activities.
And in what context have they approached that hybrid?
Looking at the usually in the context of a challenge to a decision either to prosecute or not to prosecute, as to the extent to which they were required to apply, for example, the Code for Crown Prosecutors, and if not, what test they were meant to apply.
And so is your answer to the question, it is too simplistic to put a label on them of public prosecutor or private prosecutor?
Yes.
Did you consider, for the purposes of your report, incidentally that can come down from the screen, the policy and practice of any other classically private prosecutor other than the Post Office?
I think on the definition I've just given, clearly I looked at a number of agencies that did prosecute but which did not have the Prosecution of Offences Act as their bedrock for doing so, like the Environment Agency, for example. But in terms of an organisation, for example, a supermarket chain that prosecutes theft itself, or organisations of that sort, no, I didn't look at their practice.
So you looked at some that might or have been described as hybrid,
Yes,
including the Environment Agency.
yes. And the Department of Work and Pensions is arguably another example of that. It has a statutory basis for what it does, but it's not a police-related prosecuting organisation.
And so for the purposes of these two reports, you've looked at their policy as opposed to their on-the-ground practice.
I've looked at their practice insofar as that is identified by their policies, and their recognition in those policies of what statutory requirements applied to them, rather than, as you say, looking at how they actually made decisions on the ground.
And you're proposing to examine the practice of the Post Office, in fact, between the years 2000 and 2013 in your Volume 2 report.
Yes.
But you're not proposing to, because it's an exercise I don't think that could realistically be done, compare that to the practice of other truly private or hybrid private prosecutors in that 13-year period.
No, I took my instruction for the purposes of this volume, so far as I was looking at practice as well as law, was to look at the policy position in relation to the Post Office and where I could obtain it other agencies, to see what that told me about their practice. But so far as the Post Office practice is concerned, that is very much Volume 2.
Thank you very much. In terms of the relevant period, if we can look please at page 7 of your Volume 1 report. Page 7, please. And look at paragraph 6. You say that you have endeavoured with the assistance of Catherine Brown and the Inquiry Secretariat to obtain the versions of statutory provisions, codes of practice issued under statute, guidelines and guidance, case law and other relevant material that had application during the period from 2000 to 2013. It's not always been possible to do so with certainty as to completeness. I've made clear that which I've seen. I'm not conscious of having been deprived of access to any material necessary for me to reach the conclusions I've set out below. If further material is identified, I'm happy to consider it and, if necessary, address it in an addendum to this report. And so you're making the point there, essentially by way of caveat, that you have used every endeavour to find the iterations of the guidelines and guidance and other material that was applicable in the relevant period, but have not always succeeded.
No, and an example of that is the Code for Crown Prosecutors, because it is available on the CPS website. It is available on that website in its present form. I was and I'm conscious that that's a code that has evolved over time, but it was only, I'm afraid, quite recently that it occurred to me where, in the back of Blackstone's, of all places, to find earlier versions. And so at the time I wrote Volume 1, I was looking at the 8th edition, as I make clear, rather than earlier versions.
We'll come to it in due course, but the Code for Crown Prosecutors 8th edition, I think, was dated October 2018.
Yes.
And you have helpfully found for us 2 earlier iterations. If we can just show those on the screen so everyone's got the references, please. RLIT 40171. And this will come up for you. Thank you. Is that a copy of the 2009 edition of the Code for Crown Prosecutors?
It's the 2009 Blackstones and therefore the 2004 Code for Crown Prosecutors, the 5th edition.
Thank you for that correction. So 2004 in the 2009 edition of
Yes.
Blackstones. And then equally, if we can look at RLIT 40170. Is that the edition that was in the 2012 Blackstones?
Yes, which is the 6th edition, the 2010 version of the code.
Thank you very much. We'll come later to whether there are any material differences to the opinions that you give by looking at the back issues
Yes.
of the code within the relevant period.
Yes.
Thank you. That can come down. Just looking at other comparators still, that excursion into back issues over. As far as the DWP, the HSE, the Health and Safety Executive, and the Environment Agency are concerned, you, I think, have only had sight of their more recent policies, is that
Yes,
right?
that's right.
As opposed to all of the back issues that would have been operative in the years 2000 to 2013, is that right?
Yes, for the same reason that that is what was available on their website.
And so that's a limitation, is this right, in that you can't make a direct comparison to the actual policies that were in place or may have been in place in those institutions throughout the entirety of the 13-year period?
No, that's right.
Your instructions required you to consider both the law and the practice of a private prosecutor during the relevant period. And would this be fair? You focused in your report primarily on the Crown Prosecution Service as a comparator.
Yes.
Would it be the case that any comparison between the practice of the Crown Prosecution Service and the practice of the Post Office would have to be based on the actual practice of the Crown Prosecution Service during the relevant period, rather than just its written guidance and policies? Or is there a value in the exercise that you have nonetheless performed?
It seemed to me that because, for the purposes of Volume 1, I was looking at that which was on paper, effectively, so what the law was, but also how that had been addressed by prosecuting agencies, that there was a valid comparison between looking at how different prosecuting agencies approached the same challenges in practice. Clearly, one could then go on to look at how well or otherwise those issues were addressed in practice by different prosecuting agencies. It seemed to me from my instructions that really at that stage I was being asked to focus on the Post Office rather than to carry out an audit of how well or otherwise other prosecuting agencies did in that period.
So you weren't asked to audit for a decade and a half whether the CPS across the country in fact complied with its written policies?
No. And I'm aware that there are inspectorate reports, for example, in relation to the Crown Prosecution Service, because it does audit its activities in that way. I wasn't asked to, and I haven't looked at those for that reason.
Is that by a CPS inspectorate?
Yes.
Is there, to your knowledge, any equivalent of such an inspectorate for the Post Office Limited?
Not that I've seen, no.
Okay, can we turn then to some general questions before we get into the detail? Would you agree that the supervision of the investigation of criminal offences and the supervision of the instigation and conduct of criminal proceedings is immensely important?
Yes.
Is that because it's important to ensure that the application of the criminal law to individual citizens is not oppressive, unjustified or misconceived, but is instead fair and reasonable?
Yes, and consistent.
Can we turn, please, to page 7 of your first report, please? Page 7. And look at paragraph 8 at the foot of the page. You helpfully give us an overview of your conclusions at the beginning of your report, and then there is a very substantial section at the end of your report setting out your detailed conclusions.
Yes, that's right.
If we can start, please, with an overview of your conclusions to
Yes.
let us know where we're heading. You tell us in this paragraph that throughout the relevant period, and indeed for a significant period before that, there had been a network of statutory requirements, regulation provided through codes of conduct issued under statute, and other forms of directly applicable and mandated guidance in place. This sought to ensure that the procedures employed and decisions taken by investigative and prosecutorial bodies were fair, transparently auditable, and accorded with the interest of justice. The structure erected by that network of material was detailed and therefore complicated. It required those engaged in the investigation and prosecution of crime to receive training, instruction, and guidance for each important stage of their duties. And so what you describe there, the network of materials from statute down, that was intended to achieve the aims that we have just discussed, fair, reasonable and consistent application of the criminal law.
Yes.
And at this point, is this right? You're drawing no distinction between public and private prosecutions?
No.
Can we turn, please, to page 145 of your report? And just look at paragraph 335 at the bottom. If we just scroll up a little bit, so we can catch 334. There you essentially repeat what we've just looked at in the overview.
Yes.
And then you carry on here in the conclusions, 335. Those requirements, that's in the network of instruments, applied in critical respects every bit as much to a private prosecutor or non-crime agency investigation as to a police investigation or a CPS prosecution. This was made clear, for example, in the Crown on the Application of K against Leeds Magistrates Court, 2018 EWHC 1233, in which Mr. Justice Sweeney observed, at paragraph 23, quote, "A private prosecutor is subject to the same obligations as a minister for justice, as are the public prosecuting authorities, including the duty to ensure that all relevant material is made available both for the court and the defence." And that, close quotes. And then you say, although that was a case decided in 2018, that was a position that had been made clear for a considerable period before that. Now, given the importance of the point that you have made based on the extract from the Divisional Court's decision in K and an additional sentence after the one you quoted and some questions I'm going to ask you in a moment. I think it may pay dividends unusually to look at the decision itself. I'm not going to do this very frequently, you'll be pleased to hear, because for many documents you've quoted and extracted them in full in your report. So the decision in K is our tab D23, which is RLIT 40117. Thank you very much. You'll see that it's a decision of a divisional court consisting of Lord Justice Gross and Mr. Justice Sweeney. And we see from the top right, it was a decision made on the 23rd of May, 2018.
Yes.
And it's reported under the neutral citation number that I've just given. And if we go to the second page, please. We'll see that Mr. Justice Sweeney gives the judgment, and then right at the end we'll see that Lord Justice Gross agrees with him.
Yes, he does.
If we can turn to page, I think it's 15. And scroll down, please. And again. In fact, it's just on the next page then. Looking for paragraph 23. Thank you. Under the cross-heading of the duties of a private prosecutor, the court said it's not disputed that authorities such as, I'm not going to cite them all, they are by name of party Watts, Charlson, Dacre, Barry, Zinger and Haig, ... establish that. And then one, if we just scroll down, thank you. Whilst the Code for Crown Prosecutors does not apply to private prosecutions, a private prosecutor is subject to the same obligations as a Minister for Justice, as are the public prosecuting authorities, including the duty to ensure that all relevant material is made available both for the court and the defence. And then the second point, and this is what I just wanted to pull out of this decision. The court says that those authorities establish, secondly, quote, advocates and solicitors who have the conduct of private prosecutions must observe the highest standards of integrity, of regard for the public interest, and duty to act as a Minister for Justice, in preference to the interests of the client who had instructed them to bring the prosecution, owing a duty to the court to ensure that the proceeding is fair. In your report, you said that although this case was decided in 2018, the position set out in these paragraphs was one which had been made clear for a considerable period before 2018.
Yes.
And if we just scroll up, please. You'll see that what the court says is it's not disputed that, and then there's a list of authorities, establish those two principles. The first of those cases referred to ex parte Watts. If we just scroll up for the citation, and keep going, and keep going, and keep going.
I think we may just have missed it.
Okay, sorry.
Beginning of paragraph 22.
Thank you. I think we'll see that it's a decision of 1999. If we scroll down a little bit more, please. And some more. Yep, stop. It's the second case cited there, Watts.
Yes, I think that may, with all due respect to Ms. Justice Sweeney, be a typing error. It's actually a case from 1992. So it's 1992 two criminal appeal reports, 188, rather than 1999. And perhaps in this context worth noting that in that case, where they concluded that a private prosecutor was subject to the same obligations as the Minister of Justice as a public prosecutor, they relied on a decision called George Maxwell Developments Limited, which was a decision from 1980 that said the same thing.
And so when in your report you said that although the case was decided in 2018, K,
Yes.
it was a position that had been made clear from a considerable period before that, were you relying on this list of cases, essentially, to ground that point, or your experience, or both?
Both.
And so this wasn't something that came out of the clear blue sky from Mr. Justice Sweeney in 2018?
No, not at all.
And so in answer to a question, are you able to appoint to any authorities relating to private prosecutions before the period 2000 to 2013, which made clear the duties and positions that you refer to, you would say yes, see that list of cases there?
Yes. And those that those cases in turn relied on.
And so in general terms, how well established would you say it was or not that the principles that are set out by the court in paragraph 23, 1 and 2 were embedded or not in the law?
Sorry, they were well-established principles which were restated by the court in that case, rather than it being anything new in 2018.
Thank you. That can come down. Would you agree that K emphasises what the duties are, and that the fact that they exist for both private and public prosecutors, rather than saying that a public prosecutor and a private prosecutor have to discharge them in the same way?
No, that's right.
So the obligation is one of outcome, of result, rather than means?
Yes, which is why, for example, it makes clear at the first of those paragraphs that the Code for Crown Prosecutors does not apply to a private prosecutor, because it is, on the face of it, a document for the Crown Prosecution Service. But the underlying approach to decisions on prosecutions have been recognised to be the same in effect for a long period before that, not least because a defendant, it is well recognised, had the right to know what test was being applied in a decision to prosecute them, whoever it was making the decision to prosecute them. And
so K, and indeed no other case, does not establish that the Post Office was under an obligation to have the same policies as the CPS?
No, as it happens, certainly from 2007, the documents that I've seen from the Post Office did indicate that they were going to apply the Code for Crown Prosecutors. But that was a choice that they made as to the test, as indeed other agencies had done. For example, the Department of Work and Pensions or the Environment Agency.
You use a phrase in paragraphs 9 and also in 335 of your report that the network of instruments that you have described sought to ensure that the procedures employed by investigators and prosecutors are, quote, transparently auditable.
Yes.
Can you explain what you mean by transparently auditable?
First, what I mean by that is that for there to be proper supervision of those who are making those decisions, it is important that the criteria that they are applying are identifiable so that those supervising them can test what they have done against those criteria. Secondly, it's important that a court that is dealing with a case brought by that agency is able to understand the criteria that have been applied. And thirdly, it is important that those who defend in such a case understand the criteria that have been used to make the decision, for example, to prosecute.
And so even if the Post Office did not owe, say, public law duties in terms of the publication and accessibility of its investigative and prosecutorial policies and guidance, that would not be a reason not to have such investigative and prosecutorial policies and guidance.
No, and the risk that would be run if an agency didn't have that kind of policy in place is firstly that decisions could be taken arbitrarily, secondly they could be taken inconsistently, and thirdly it would be difficult for them to justify those decisions if challenged, if they weren't able to point to the basis on which they'd reached them.
Thank you. Can we go back then to the overview, page 8 of your report, please? And it's paragraph 9 and following that I'm going to take you through, if I may. And so this is before we get into the detailed reasons for your developed conclusions. I would like, if I may, to address briefly the conclusions in overview form. And you set them out from paragraph 9 onwards. And you say that you have reviewed the Post Office policies in relation to the investigation, prosecution and related areas, and have concerns as to their adequacy to achieve these objectives. The policies recognise that the Post Office as an investigator and prosecutor was and is subject to PACE and the CPIA and the codes issued under each Act. However, in particular, during the earlier period from 2000, policies referred to that fact without setting out the ways in which this was the case, the specific acts of those acts and codes that applied, and the ramifications of those to those undertaking investigation and prosecutions.
Yes.
You say in the first sentence that you have concerns as to the adequacy of the Post Office policies in the relevant period. Can you calibrate your level of concern for us, please?
In a sentence, my concern in relation to particularly the Criminal Procedure and Investigations Act is that there are various policies that acknowledge that it exists, but they don't identify within the policy which parts of what is quite a substantial piece of legislation those who are undertaking work for the Post Office were meant to be applying, or how they were meant to be applying it. And clearly, as we'll go on to, training plays a role in that, but my concern is a real concern, is that it is a different thing to say this Act applies to you and to say this part of this Act applies to you and this is how it applies to you and this is what you are meant to do under it. If you do the latter, there is much greater chance that it will be done correctly. And so I think it is a serious concern that there was acknowledgement rather than explanation in relation to those very important pieces of legislation which are in place to ensure consistency and fairness in investigation and prosecution.
And so what's the vice of bare reference to the application of a statute in a policy? By the way, the PACE applies to your investigations or CPIA applies?
The risk is first that someone will have received training when they started and they will recall that there was this piece of legislation, and it had parts that applied to them, and they will rely on their memory. They will look at the Police and Criminal Evidence Act and see that it is vast and stop. And there is the risk that they will look at the Act, find a part that they think is the right bit, look at it and do their best to understand it. But on that approach, you may have any number of different interpretations operating within the same prosecuting agency rather than one clearly defined one, which is why other agencies, and the Crown Prosecution Service is an example of this, have detailed guidance on the approach to different parts of these acts so that there is a consistency, at least the intention is there would be a consistency in how it's applied.
And so your expectation is that there oughtn't to be just bare references, but an explanation as to how the relevant parts of the legislation, a code or other instrument are to be carried into effect in this organisation.
Yes.
Can we turn to paragraph 10, please? You say in some respects the policy documents themselves differed from training materials which did seek to address the PACE codes of practice and do identify which parts applied in what context. However, such training materials did not represent a suitable alternative to policy documents which themselves steered the correct path through the application of PACE or the codes thereunder. Such training documents would not necessarily ensure the application of up-to-date regulation. I've also not seen comparable training materials relating to the CPIA or the code thereunder, save in relation to the retention of investigators' notebooks until 2012. Why would training material not represent a suitable alternative to policy documents which steer the correct path through, in this example, the application of PACE or the codes issued under it?
I should say in relation to training materials that when I initially started to prepare this report, and indeed produced a first draft of this report, I hadn't seen any real training materials at all. I then received them, and in relation, for example, to the codes of practice under the Police and Criminal Evidence Act, which are codes to address, for example, how interviews are correctly to be undertaken, how searches are to be undertaken, matters of that sort. The training material did identify this is the code of practice that applies to this activity, for example, interviews. These are the parts of the code that applied. And they were correct and clear in that training document. But the codes change. And so there is the risk that if someone is relying on their training notes, that they may not be looking at an up-to-date version of the code or appreciate that that is the position. The fact that the training documents were able to set out that kind of analysis and that kind of application, to my mind, underlined the importance of the policy documents doing that as well, because the point of putting it in the training is so people understand how the code applies to them. Well, similarly, in my view, a policy document should do that. And so it could never be a substitute for a policy addressing the responsibilities of, for example, an investigator in sufficient detail so that they could do so lawfully and consistently and fairly. For them to rely on training material instead seemed to me an unsatisfactory alternative because it could well be out of date.
And so, although the training materials focused on, I think you've mentioned the conduct of searches,
yes,
and interviews in particular.
Yes.
The second level of concern that you express here is that you had not seen comparable training materials in relation to the CPIA.
No, and that is the statute that regulates the disclosure process and sets out the responsibilities of investigators and the supervision of those investigators by prosecutors. And so the detail of the requirements of that act are centrally important to those processes being undertaken consistently and fairly. And I didn't see training material that did that drilling down into those requirements and why they applied and how they applied and who they applied to, in the same way that there had been training material that addressed the Police and Criminal Evidence Act.
And so in relation to duties of disclosure and the duty to pursue reasonable lines of inquiry,
Yes.
there was an absence of both policy and training materials.
Yes.
And how, if you can again calibrate your level of concern as to that, please.
I think it's a very serious concern if the position that an investigator or a prosecutor is left with is that it is left to them to do their own research of an important piece of legislation, for them to work out how they think it applies to them, rather than it being clear to them from the policy that they are required to apply exactly how it applies to them and what they're meant to do under it. There is a very real risk, in my view, if you leave it to initial training or self-interpretation, that things will go wrong.
Turn to paragraph 11, please. You say during the relevant period, the degree of detail and guidance in the policies did improve and was thorough, for example, as to the conduct of interviews.
Yes.
You've just said that. Did that seem to be a topic that was marked out, how post office investigators should interview their suspects?
Yes, there was an increasing amount, and certainly by the latter part of the period, a good deal of material, if almost too much material, in relation to interviews, which was in stark contrast to other areas like disclosure.
Moreover, there was guidance for the disclosure of unused material in place from at least 2001. However, there were other aspects of the structure of statute and regulation that were not addressed in detail, and in some instances not really addressed at all. And you would identify the following areas. One, there was a lack of explicit instruction to investigators to undertake or prosecutors to monitor the CPIA code requirement that, quote, in conducting an investigation, the investigator should pursue all reasonable lines of inquiry, whether these point towards or away from the suspect. What is reasonable in each case will depend on the particular circumstances, end quote. And you say this duty is of central importance to the securing of a fair trial, not least through the achieving of fair and adequate disclosure. Again, if we can just go back to that, please. That first concern, the lack of instruction to investigators and lack of instruction to prosecutors in relation to that code requirement to pursue reasonable lines of inquiry that point towards or away from the suspect. Can you calibrate your level of concern in relation to that, please?
That is a fundamentally important requirement, because it makes explicitly clear to both an investigator in then undertaking an investigation and a prosecutor in their review of that process that the requirement for the investigation is to look at all lines of inquiry, including those leading away from the person that you are investigating. And it is, in my view, fundamental that is a guiding light to any investigation and any review of an investigation. And if, as was the case, the disclosure policy, for example, of the Post Office did not refer to that requirement until 2010, that is a serious omission, because it does not put front and centre in policy terms for those doing those roles that is what they are meant to be doing.
You said there, we'll come back to this in more detail in a moment, that the disclosure policy didn't even refer to the requirement until 2010. When had the requirement entered into the law?
It had applied throughout the period of concern for this inquiry. and it was not included in the 2001 disclosure policy, which was otherwise designed to address for the Post Office how they were meant to undertake disclosure in accordance with that Act of Parliament and the code thereunder.
And if we go to B over the page, please. You say, secondly, the AG's guidelines. We're going to come back to this in a moment, but can you summarise what the AG's guidelines were, please?
Yes, so those were a series of guideline documents starting from the year 2000, which were designed to flesh out the requirements for investigators and prosecutors as to how to undertake their disclosure responsibilities. They were a recognition by a succession of Attorney Generals that for there to be fair and consistent disclosure, they needed to give more guidance than the CPIA or the code that under that had already given. And so they address stage by stage what investigators and those supervising them and what prosecutors and those supervising them had to do and how they were to work with each other.
Thank you. You say that they were not addressed. This limited the guidance as to the role of prosecutors in overseeing, monitoring and securing proper compliance with the requirements of disclosure. It also meant that there was almost no guidance as to the handling of third-party disclosure throughout the inquiry's relevant period. And so you mentioned two consequences there, or two facts there. Again, can you calibrate the level of concern that you had in relation to those two issues, or each of those two issues, please?
So as we will see, I anticipate, the 2001 policy in relation to disclosure acknowledged that there was an Attorney General's guideline in relation to disclosure. Interestingly, the 2010 version didn't. But that was the extent in the material that I have seen of that recognition. And so there was at least the risk that those who were seeking to engage in the disclosure process would overlook the Attorney General's guidelines and therefore overlook the detailed guidance that those guidelines gave them for how to do their job correctly and fairly. And third-party disclosure is...
Just tell us what you mean by third-party disclosure.
So that is material that is not in the possession of the prosecutor or the investigator, but which they have reasonable grounds to anticipate a third party would have. So, for example, an investigator who is relying on computer data that is provided by a computer system operated by a separate entity would recognise that that entity was likely to have material that was relevant to the reliability of the data. And that would be third-party material. And the Attorney General's guidelines have always made clear that there is a responsibility on investigators and prosecutors to identify where there may be such third-party material and to take steps to obtain it so they can review it for disclosure. That is something that is addressed primarily, in fact, in the Attorney General's guidelines rather than the CPIA or the code thereunder. And so if one is not looking routinely at the Attorney General's guidelines, one could miss that important responsibility. And if there is no reference in your policy to third-party material, again, there is a risk that it will be overlooked.
And how, again, would you calibrate your level of concern in relation to that issue?
I think if one is assessing, insofar as one can, the practice from what was written down, it is a very significant omission because if there's no reference to the Attorney General's guidelines in your policy, it's difficult to see how you can be satisfied that they will be applied nonetheless. And they have to be because they are fundamental to getting the disclosure right. And
just at this point, may I ask, if you carried out, as an investigator and prosecutor, a set number of types of investigation. They might be robberies on branch, they might be burglaries of branches, they might be thefts in the mail, they might be fraud committed by customers, they might be fraud committed by post office staff, using our umbrella term. And the sources of third-party data are different for each of them. Would your expectation be that the policy should say, for X species of investigation, we habitually rely on this data to either prove or disprove the offence, and one must therefore consider the following categories of material that should be sought, or the data is held in this repository. This is the contact of the person in that repository to get the data from. Would that be your expectation?
It would certainly be the safest way to make sure that it was undertaken properly. I don't think on the material that I have seen it could be said that that was how other agencies were routinely undertaking that responsibility. But they were, for example, the Crown Prosecution Service in their policy documents were identifying in detail what the disclosure requirements were in relation to third-party materials, so that anyone undertaking a disclosure exercise by reference to their policy would know that they had to consider that topic. But obviously the Crown Prosecution Service are dealing with a much wider range of offences and situations. If an agency had a more limited range, then they had greater scope to give greater help to their investigators and prosecutors in how to do those more limited range of offence investigations well.
Thank you. Can we turn to paragraph 12, please? You say, I consider that the policy landscape, and by that do you mean the post office policy landscape?
Yes.
I consider that the post office policy landscape for a significant period was not sufficient to ensure consistent and comprehensive compliance with a number of important aspects of the Police and Criminal Evidence Act and CPIA regimes, and in particular in relation to independent decisions as to charge, disclosure of material that might undermine the reliability of data systems, and third-party disclosure. It will be readily appreciated that each of these is an area of importance to the inquiry's terms of reference. This is an overarching conclusion, is that right?
Yes.
And in it you highlight, firstly, concerns as to independence of decision-making as to charging.
Yes.
You highlight, secondly, concerns over the disclosure of material that may undermine the reliability of data systems. And you highlight concerns over obtaining third-party disclosure.
Yes.
Again, can you calibrate the level of your concern in relation to each of those three, please?
Those were areas that I was alive from my instructions, were areas that certainly by the time I come back in December I will need to have addressed. But at this stage, looking at the policies and how well they equipped the process for those things to happen, though I had concern as to whether the policies did properly ensure independent decisions as to charge. So that's decisions by lawyers applying identified criteria to make that decision, rather than there being a risk that non-lawyers were ultimately making those decisions, and if so, on what criteria they were making them. And the policy position in relation to that was unclear, at the very least, to me. And so I have a concern about that, but I recognise that might be a concern that could be allayed by a detailed understanding of how the decisions were actually made in the cases. And so that's perhaps one I will have to return to in Volume 2.
And what you've read so far of the Volume 2 material, has that allayed your concern, not affected your concern, or heightened it?
I think heightened it in the sense that I have seen evidence of recommendations from investigators as to whether there should be a prosecution, and if so, for what. I have seen evidence of lawyers providing advice, albeit I have to say that those advices have been brief. But it's not clear on what I have seen who then actually made the decision and on what basis. And that is an area that the policies left opaque to me, and the material I have seen has not clarified. So that what I thought was a risk does look like it is materialising in the material I've seen for Volume 2.
Thank you. The second concern, disclosure of material that may undermine the reliability of data systems. Again, if you can calibrate your level of concern there.
Because the evidence that I saw of training in relation to disclosure, of policy guidance in relation to disclosure, and the lack of cross-reference to the fundamental sources of guidance as to disclosure was as it was, and because I did not see anything that highlighted disclosure of material that might undermine reliability as a topic at all, that was and remains a very real concern to me, because it has the potential to result in fundamental failures of disclosure through omission of instruction.
And then thirdly, an insufficient policy landscape concerning third-party disclosure.
But the reality as I saw it, barring a reference in 2001 to the existence of an Attorney General's guideline, was that there was no internal Post Office policy guidance as to third-party disclosure, and therefore the very real risk that could be overlooked. And that could have fundamental consequences, clearly.
So I missed what you said there. That could have
fundamental consequences, because if one has not appreciated that you don't just look at what you have already got as part of your disclosure, but what you ought to get as part of your disclosure, then there's the real risk that you won't get it. And if you don't get it, you won't review it. And if you don't review it, you won't disclose it. And if you don't disclose it, then important disclosure necessary for fairness will not happen.
Can we turn to paragraph 13, please? You say, similarly in relation to decisions to charge, I do have concerns about the adequacy of policy guidance to achieve a proper division of responsibility so as to achieve independence, transparency, accountability and consistency. Whereas in other areas, for example, pursuant to the Prosecution of Offences Act 1985, such a division is instilled and maintained, the Post Office policies left it open for the same person or group of persons to make key investigation and prosecution decisions, while such prosecutions were, by reference to a number of important policies, to be undertaken with the application of the CPS Code for Crown Prosecutors. There was, in my view, a lack of detailed guidance as to how this was to be done, or how compliance with proper standards was to be achieved or monitored. You mention that you have concerns about the adequacy of policy to achieve independence, transparency and accountability and consistency. Again, if you can calibrate the level of your concern, please.
So I recognise that the Post Office is not the Crown Prosecution Service, and it's not under the Prosecution of Offences Act, so that decisions as to prosecution are taken in a clearly defined way that is separate from investigative decisions taken by the police. But it is recognised much more generally, including for private prosecutors, that it is important that the decision to prosecute is taken in an independent, accountable way, and the expectation certainly that would be done by a lawyer. The policies that I saw left room for an interpretation that although legal advice was being provided, it was not necessarily the lawyer that was making the decision. It could be, on some of the policies I saw, with input from HR or from the Director of Security, who was also the person responsible for supervising the investigation. And so you could have the investigator deciding on the prosecution, having received legal advice, but by no means clear whether they had to follow it or not.
You mentioned that although there was a cross-reference to the Code for Crown Prosecutors, there was a lack of detailed guidance as to how it was to be applied and how compliance was to be achieved or monitored. Again, can you calibrate the level of your concern about that issue?
Again, on the material I saw, it's a very real concern, because if the interpretation I've just described is right, and the person making the decision, albeit on legal advice, may not be a lawyer, then they need all the more clear guidance as to how the two tests within the Code for Crown Prosecutors, which are the realistic prospects of a conviction and whether a prosecution is in the public interest, how those work for the offence they're considering, the offending that they're considering, or alleged offending that they are considering. And that needs specific guidance. The material that I saw acknowledged that the Code for Crown Prosecutors was to be applied, but not how it was to be applied, which factors within it were likely to be particularly relevant to a post office prosecution or not. And there was also, in the material I saw, references to a series of factors that it was considered were relevant to a prosecution, which included the best interests of the business and the integrity of the mail, as opposed to the much more nuanced and detailed set of criteria that would or should be applied to a prosecution decision by reference, for example, to the Code.
Thank you. And then lastly, before we take the break, paragraph 14, you say there was a similar lack of guidance as to proper decisions as to which charges to prefer. And, for example, little guidance as to the application of the Court of Appeal's decision in Eden. We mentioned that briefly.
Yes.
Could you just summarise, before we get into the detail, probably tomorrow, what the guidance that the Court of Appeal gave in Eden was?
And so in Eden, the Court of Appeal were considering a situation where the individual who was a postmaster had been prosecuted for theft and false accounting, charges which I'm aware regularly occur in the cases that we are here considering. And there was a concern from the Court of Appeal as to the prosecution for both offences in reality on exactly the same allegation, and whether it was right to have both charges there where actually it was an allegation of theft rather than an allegation of theft and a separate allegation of false accounting. So it was a Court of Appeal decision looking at a particular factual situation, but in relation to charges that are and have been routinely used by the Post Office. And it therefore seemed to me helpful to consider the extent to which that guidance from the Court of Appeal had been acknowledged and applied by the Post Office, and the best way to see that was to see where it appeared in their policies, and the answer was that until 2013 it didn't.
And so that 1971 decision didn't appear in any policy documents?
Not in those I saw, no.
That you saw?
Yes, until 2013. Yes.
Until 2013. You continue, there was equally no reference to the Attorney General's guidelines on the acceptance of pleas until 2016. Again, can you just summarise now what the AG's guidelines on pleas?
Yes, so this was, again, the Attorney General with their supervisory responsibility for prosecutions beyond any particular agency, setting out guidance as to how properly to approach decisions as to whether to accept a plea. So, for example, using the offences we've just referred to, when it was appropriate to accept a plea to false accounting in the alternative to an offence of theft, and the criteria to ensure that that was done in a fair and non-oppressive way. So, for example, that the person being prosecuted did not feel under pressure to plead to false accounting because the theft charge was there in a way that would be unfair. And so those guidelines, which have been in place for a long time, have set out how that is properly to be done, and I didn't see a reference to those in Post Office materials until, as I say, 2016.
Thank you. You continue. I've not identified any reference to the duty of candour required in applying for a summons to initiate criminal proceedings in any of the policies I have considered where that might have been expected. Again, can you just summarise the duty of candour, in particular how it applies in relation to the point at which one initiates proceedings?
Yes, so one method of initiating proceedings, and the method that was used by the Post Office, and I have no criticism of them for that because it was the obvious one for them to apply because they were not a police force, was to summons the defendant to attend at the Magistrates' Court and proceedings initiated as a result. There is a long-standing requirement on anyone seeking a summons to what is called have a duty of candour, which is to identify to the court any relevant circumstance that may incline that court not to grant the summons. So they have to be satisfied, the court, that there's a proper basis for a prosecution, but they also need to have an understanding of whether such a prosecution might be an abuse of process, whether there's material that would make them less likely to grant the application, and that is a well-recognised duty. I saw very little material, in fairness at all, about obtaining summonses and how they were to be obtained within the Post Office material that I saw, but nowhere did I see a reference to that duty.
So no reference to the duty on the Post Office to be candid with the court?
Yes.
You say these omissions in the policy documents were consistent with the failure of the training materials that I have seen to address these topics. So in these three cases, the suggestion of cure through training wouldn't run?
Certainly not on the material that I saw.
You say, finally, I've considered the implications of the repeal of Section 69 of PACE as to the obtaining of confirmation as to the reliability of computer data. The real concern, however, is and was as to the appreciation of the need to consider reliability of computer data in reaching charging decisions as to the disclosure of material that undermined it, that reliability.
Yes.
Can you explain, firstly, what just in summary form, Section 69 of PACE was about, the repeal of it and when, and your identification of what you say was the real concern?
So when originally enacted, the Police and Criminal Evidence Act included at Section 69 a requirement for there to be a satisfaction as to the reliability of computer data as effectively a precursor for reliance on that data. The Law Commission made proposals for the repeal of that because the Law Commission considered it to be cumbersome and not to actually be achieving its objectives. There was a consultation in relation to that. A range of organisations responded, including the Post Office. There was a broad support amongst those organisations, interestingly, with the exception of one that related primarily to computer software personnel, but a broad support for repeal of the section. And so there was no longer that precursor of satisfying a reliability test for computer material thereafter. But the point I would seek to make in this paragraph is that did not mean that the reliability of computer data became irrelevant. it's always been well recognised that the reliability of the evidence that underpins a prosecution is something that investigators have to address, that prosecutors have to consider, and that, where necessary, both have to demonstrate in criminal proceedings. And so I rather took the view that it wasn't so much the repeal of Section 69 that was the fundamental question as whether the material I saw in policy terms addressed that question: is this data reliable or not?
And did it?
No. There were references occasionally to computer data, but more in the sense of how to go about getting it rather than how to go about testing it.
Thank you, Mr. Atkinson. So, with your permission, can we take the break, please, until 11:45?
Yes, of course. We'll resume then. Thank you.
Thank you very much, sir. So, good morning. Can you continue to see and hear us?
Can, thank you.
Thank you very much. Mr. Atkinson, we're turning to the Post Office as a private investigator and as a private prosecutor. And I just want to examine briefly, if I can, to start with, some of the risks that may arise for a private investigator and a private prosecutor. Can you explain what risks might arise for the Post Office in its position as a potential victim of a crime, potential witness to a crime, the investigator of the crime, and the prosecutor of the crime?
Those risks can be encapsulated in the risk that those different categorizations can become merged, and the risk that it is not clear to identify which of those hats is being worn by a particular person at a particular time, unless great care is taken to make sure that there are measures in place to keep a separation between those different categorizations.
And so would you agree that the risks might include fundamentally a lack of objectivity?
They can do, yes. And with private prosecutors, in perhaps the most literal sense, an individual who feels aggrieved and seeks to take recourse themselves to a criminal court to address that, clearly they are both the victim and the, as they perceive themselves to be, and the prosecutor. And so their decisions, which are meant to be objective decisions as to investigative steps and or prosecutorial decisions, could be taken from their perspective as an aggrieved person rather than as a Minister of Justice.
Would a second risk include the bringing of prosecutions on the basis, or the conducting of prosecutions on the basis of the furtherance of impermissible objectives? Yes,
and so again, taking that example of someone who is an aggrieved individual, that they may feel aggrieved at someone who they perceive having cheated them in a business arrangement, and their pursuit of the matter may be with a view to obtaining ultimately financial redress through confiscation, rather than whether the objective tests that ought to be applied by any prosecutor along the way have been applied.
And so overemphasising the or the use of the prosecution as a facility to recover money.
Yes. So if one of your criteria for deciding whether to prosecute or not is the best interests of the business, you may be guided by the fact that there is a loss identified to the business as a reason to prosecute, rather than stepping back to identify whether objectively there is a proper basis for prosecuting an individual in relation to that loss.
Would a third risk be a win at all costs mentality?
It could be, yes.
Would you agree that those risks, if they exist, may be multiplied or not called in to be checked if there is no external inspection or oversight of the prosecutorial process?
It's both harder to identify them at the time and harder to address them after the event if there isn't that kind of oversight.
Would you say that scrutiny of the private prosecutorial function ought to begin in-house?
Yes, and there are, I recognise, different ways that can be done and different ways that it is done by different organisations that have private or quasi-private prosecutorial functions, but that they should have that independent scrutiny and separation of scrutiny clearly is a way to ensure that there is effective scrutiny.
You've used the example in answer to a couple of my questions of a private individual aggrieved at a financial loss that they say that they have sustained. In terms of the post office, and like you in your report, I'm referring to the post office in each of its legal entities
yes.
Across the piece, and not distinguishing between when it was RMG and when it became Post Office Limited. Would you equate the post office as a private prosecutor to such an individual, or is it different in any way?
There are potential similarities in the sense that the individual who feels that they have lost financially through their dealings with a particular person and who then seeks to prosecute them clearly is both the loser with grounds certainly in their head at least to be agreed about that, and the prosecutor. Where the post office was prosecuting someone that they perceived had cheated them and had caused them loss, then they were both the person who had suffered the loss, the organisation rather that had suffered the loss, the organisation that wanted to recoup the loss, and the person prosecuting the person they held responsible for the loss.
Can I also draw some distinguishing features, perhaps,
yes.
Between those two classes of people? The Post Office have been prosecuting for hundreds of years, is that
yes.
right? And so it was an established private prosecutor.
Yes.
The nature, number and scale of its private prosecutions is obviously very different from the individual that you just mentioned.
Yes.
It had itself given over whole departments to investigative and prosecutorial work, hadn't it?
Yes.
The security department and the criminal law team, the CLT.
Yes.
To name just two. And would this in any way be a relevant feature, that the company was entirely owned by the government through ownership of a single share? Does that bear on the issues that we're looking at or not, in your view?
It certainly doesn't have to. So to take an example that was flagged up in a report that I've seen recently, that where the London Fire Service were both responsible for fire safety, but also for potentially for a prosecution in relation to a fire, the fact that they had separate parts of their organisation dealing with one and dealing with another was a factor to ensure that they were capable of dealing with that fairly. And so the fact that there are separate departments within organisation that keep them separate from their owner, for example, can overcome any issue. It depends on how it's done. And so to answer your question, the fact that the post office was effectively owned by the government, on the one hand gave them more of a responsibility to ensure that they applied policy and statute that were laid down by government to ensure that the job they were doing was done appropriately and fairly. But if they built the necessary separations and independent scrutiny into their system, then there would be no pressure on them from their owner for how they did it, or there shouldn't be.
Thank you. Can we turn to the status of proceedings that the Post Office brought? And this is page 10 of your report.
Yes, thank you.
If we can have that up on the screen, please. EXP 602. Thank you. Page 10. And if we just scroll down to get paragraphs 15 and 16. In paragraphs 15 and 16 of your report, you summarise the history of the Postal Service undertaking investigations and prosecutions of criminal offences. I'm not going to ask you about that history. Instead, on this occasion, take those paragraphs as read. In the course of that investigative work that you undertook, I believe you sought to identify the statutory basis for the Post Office's investigation of prosecution of offences.
Yes.
And you didn't find one, I think that's right.
That's right.
And I think you were heartened by some material that you found amongst the documents that you were given by the inquiry that emanated from the Post Office's then General Counsel,
Yes.
Chris Ojard, dated the 8th of November 2013. And if we can just look at that, please. It's poll 302 7501. Poll 302 7501. If you're working from hard copy, Mr. Atkinson, it's E4.
Thank you very much.
So I'm afraid we'll have to take a break. There's something gone wrong with the system. Can we leave it that we'll come back to you when that fault has been cured?
Yes, of course. I'll take myself off screen, but I won't leave the room I'm in, so that I'll be ready when you are.
Thank you very much, sir. And maybe if Mr. Atkinson can go to the room. Thank you. Sir, I can now see you. Can you see and hear me? Thank you. Apologies for that delay, and apologies, Mr. Atkinson, for that delay. We were trying to look at poll 302 7501, which I think is now on the screen. Just to orientate ourselves in the document, if we go to page 5, please. And look at the foot of the page. We can see that it's authored by Chris Ojard on the 8th of November 2013. And go back to the front page, please. we can see the document is entitled Post Office Audit, Risk and Compliance Committee and Prosecutions Policy. You can see the purpose of the policy set out in paragraphs 1.1 and 1.2, but it is what is said about the Post Office's power to bring prosecutions that I wanted to draw to your attention. We can see at paragraph 2.2, it says since that update last October, that was, Brian Altman, Queen's Counsel, has prepared 2 separate reports, etc. And then if we go down to paragraph 2.5, an important fact to emerge from the 2 reports, that's Mr. Altman, Queen's Counsel reports, is that the Post Office does not have any special statutory powers to bring prosecutions. So this is the Post Office's General Counsel saying it's emerged now that we, the Post Office, don't have a special statutory power to bring prosecutions. Rather, it brings prosecutions in a purely private capacity, further to Section 6.1 of the Prosecution of Offences Act 1985, which gives all individuals and companies the right to bring a private prosecution should they see fit. To that extent, therefore, the decision to undertake prosecutions is discretionary. No legislation or regulation requires the Post Office to undertake prosecutions, nor is there any legislative policy that mandates that prosecutions should be brought. That's not to say that the standards of evidence are in any way reduced or that the process is less rigorous than would be the case with a public prosecution. It's simply that the Post Office steps in to assume a function that typically would be undertaken by the CPS after the referral to it of a case by the police. I think you agree with what is summarised there, is that right?
Yes.
That's accurate.
It is.
And provided, as I said, a heartening reaffirmation of what you had discovered or failed to discover as a result of your own researches.
That's right.
Can we look then, please, at Section 6 of the Prosecution of Offences Act, sometimes called the POA 1985, as it's a foundational provision for the bringing of prosecutions. And that document, please, is at RLIT 5073. That's the front page of the POA as originally enacted. If we can scroll down, please, to Section 6. So I think that's on about page 4. Thank you. Section 6, prosecutions instituted and conducted otherwise than by the service. The service means the Crown Prosecution Service, correct?
Yes.
Subject to subsection 2 below, nothing in this part shall preclude any person from instituting any criminal proceedings or conducting any criminal proceedings to which the director's duty, the director being the director of the Crown Prosecution Service.
Yes, Director of Public Prosecutions, yes.
Yes. To take over the conduct of proceedings does not apply. Subsection 2, where criminal proceedings are instituted in circumstances in which the director is not under a duty to take over their conduct, he may nonetheless do so at any stage. And so this is essentially the power to bring private prosecutions reflected in statute. It's not obviously a requirement to bring such prosecutions.
That there was always recognised to be a right to bring a private prosecution. What this Act did at this point in time was to preserve that right, even though in other respects it was creating the Crown Prosecution Service and setting out the duties of the director in relation to the bringing of prosecutions for various agencies, including the police, more generally.
Can we go back, please, to poll 302-7501, which is the document we were just looking at, the Chris Ojard document? Thank you. And can we look, please, at paragraph 2.4, which we skipped over towards the foot of the page? Thank you. The policy says the forward-looking report, that's Mr. Altman's report, is similarly positive in tone, with Brian Altman commenting that he had, quote, seen no evidence to suggest that the Post Office Limited exercises its investigations and prosecution function in anything other than a well-organised, structured and efficient manner through an expert and dedicated team of in-house investigators and lawyers supported by Cartwright King solicitors and their in-house counsel. I'm not going to ask you about that assessment. We're going to come back to that rosy assessment later in the year and into next year. The document, the policy continues. That said, it was noted that, quote, Post Office Limited's prosecution role is perhaps anachronistic and that Post Office Limited is the only commercial organisation, albeit government-owned, I can think of, apart from Royal Mail Group, who retains a residual prosecuting function, that has a prosecution role, and it is, to that extent, exceptional, if not unique. The policy notes that, relying on what Mr. Altman had said, that the Post Office's prosecution role is anachronistic and exceptional, if not unique. In your researches, did you find or uncover any similar organisation to the Post Office?
No, and in my report I highlighted a further document, again from Mr. Ojard, which is paragraphs 17 and 18 of my report, where he undertook a further analysis of that suggestion of the role prosecutions, the Post Office's prosecution role being an exceptional one, and he highlighted that other financial institutions, even with in-house investigative teams, would usually hand over their cases at a particular point to other prosecution and investigative agencies rather than carrying out that role themselves. And even those that did undertake a prosecution role themselves, like Transport for London or the RSPCA, were focused in doing that on persons outside its organisation, whereas the Post Office, of course, was prosecuting not only persons from outside, but also in-house, in the sense of prosecuting its own employees themselves, rather than it being dealt with by others. And so in those respects in particular, I would agree that it was exceptional, and I didn't find any comparable organisation.
Thank you. That can come down now, please. Can we go back to your report, please, at page 13, please? So or it has been established that, generally speaking, the Post Office has no special investigative powers and no special prosecutorial powers.
Yes.
Can we look at paragraph 22, please? you say it follows from this independent role that the Post Office, as an investigative and prosecutorial agency, has always operated separately from the agencies and mechanisms of mainstream investigation and prosecution of crime, in particular the police in relation to the first and the CPS to the second. It is, however, entirely appropriate to consider the Post Office in the undertaking of criminal investigations and the prosecution of criminal offences by reference not only to the statutory regime and guidelines that had direct application to the Post Office in these capacities, but also to the statutory regime and guidelines that applied in the same time period to the police and the CPS. The relevance of the latter is both that it provides a benchmark against which to assess investigatory and prosecutorial practices by the Post Office between 2000 and 2013, but also because in important respects there was an expectation by Parliament and the judiciary that they would have regard to them. Does this essentially, in this paragraph, set out the foundation of your approach?
Yes, and I should make clear, I recognise that the Post Office was entitled as a private prosecutor to devise its own approach to areas that the police and or the Crown Prosecution Service dealt with, but it seemed to me a good way of testing the effectiveness of those to see not only what the police and the CPS had in policy terms set out, but what the purpose of that was, and to see whether those purposes were also comparably being addressed by how the Post Office in policy terms was doing it.
Now, what you're saying is that, is this right, the materials, whether they're statutes, codes, guidelines and policies, which make up the framework or the network that you have described, have importance in three ways. Firstly, in some cases, they may be directly applicable.
Yes.
So some parts of the CPIA 1996 are directly applicable and bind as a matter of law the Post Office.
Yes.
When it's acting as a private prosecutor. Secondly, those materials, even if they're not directly applicable to the Post Office, they provide a benchmark against which to judge the Post Office's policies and practices and ultimately its conduct.
Yes.
And thirdly, in any event, there was an expectation by Parliament and the courts that private investigators and prosecutors would have regard to such policies and practices.
Yes.
Can I turn to the separation of the investigative and the prosecutorial functions? In a number of passages in your report, I don't ask for them to be turned up, but they're paragraphs 26 to 35 and 55. You are critical of the Post Office's policies for not spelling out the separation of functions between the investigative function on the one hand and the prosecutorial function on the other, based on a comparison with the positions of the CPS and the SFO. Is that right?
Yes, or that's more precisely that the Post Office policies that I saw allowed for or didn't prevent a merging of investigative and prosecuting decision making in a way that, in their different ways, that the CPS and the SFO had, and other organisations had.
It's right that the CPS and the SFO are both creatures of statute.
Yes.
And the statutes that create them ensure and have hard written into them the separation of investigative and prosecutorial functions.
Certainly the Prosecution of Offences Act very much creates a distinction of investigative and prosecutorial roles and makes clear that the CPS only occupies the latter of the two. The SFO is different from that in the sense that the director of the SFO has a responsibility for the investigation of fraud as well as the prosecution of fraud. But there is the clear expectation in that, not least through its supervision by the Attorney General and Parliament, that those roles will be kept separate, and that is and has always been very clear in how the SFO has conducted itself.
So the answer to my question is yes, so far as the CPS is concerned, hard written into the statute.
Yes, absolutely.
No in relation to the SFO.
That's right.
Thank you. Can we look, please, at page 17 of your report? And look at paragraph 29 at the foot of the page. Sorry, did I say 17? I meant 15. 15 of your report, paragraph 29 at the bottom. Thank you. You say the status of the Director of Public Prosecutions and the superintendents of the Crown Prosecution Service by His Majesty's Attorney General is recognised to have significant importance. For example, in the Crown against the Director of Public Prosecutions ex parte Manning, 2001 QB 330, Lord Bingham of Cornhill, the Lord Chief Justice, observed in the context of a challenge not to prosecute by way of judicial review at paragraph 23, quote, as the decided cases also make clear, the power of review is to be sparingly exercised. The reasons for this are clear. The primary decision to prosecute or not to prosecute is entrusted by Parliament to the Director as head of an independent professional prosecuting service, answerable to the Attorney General in his role as guardian of the public interest and no one else. There is no comparable oversight of the investigative and prosecutorial activities of the Post Office, you add. What, if anything, do you say are the importance of Lord Bingham's remarks in Manning to the present issues that we are considering?
What underscored what Lord Bingham there was saying, in effectively saying that it would be rare for a judicial review of a prosecutorial decision to be successful, was that the reason for that was that Parliament had entrusted prosecuting decisions to the Director, the DPP, but more than that, that was because the DPP was the head of an independent professional prosecuting service that was answerable to the Attorney General and thus to Parliament. And so in that context, the safety of prosecutorial decisions came from that combination of oversight and independence. Where that combination is lacking or more limited, the confidence one can have in prosecutorial decisions is equally reduced.
Thank you. You say at the end of the paragraph that there's no comparable oversight of the investigative and prosecutorial activities of the Post Office. Is that right? Is there no oversight?
Not in the material that I saw, and I'm very happy to be corrected on it, but certainly there was identification of oversight within the Post Office. So, for example, the Director of Security had oversight of investigations, but not in the way that there was the independent external oversight that there is for the CPS, by way of example.
Did you find amongst any policy document or guidance document that you were provided with any requirement that mandated Post Office board oversight of the Post Office's investigative and prosecutorial activities?
Not that I can think of. I'm very happy again to be corrected, but not that I can think of.
No, my purpose wasn't to set you up for a fail on that one. It was to establish the position. So looking at internal scrutiny and oversight, you didn't see anything in the policies that mandated board oversight of this important function of investigation and prosecution?
No.
Can we look, please, at page 23 of your report? And look at paragraph 48 at the bottom. you're dealing here in this part of your report with the distinction of roles, the separation of powers and responsibilities between investigators on the one side and prosecutors on the other.
Yes.
In other organisations. And you're establishing, I think, in paragraph 48 and the following paragraphs, that distinction or separation of roles amongst certain public investigators and public prosecutors, here the police and the CPS. And you're identifying where that distinction of roles is recognised and what I've called as hardwired into the system. Is that right?
Yes. And
you start at paragraph 48 by looking at section 3 of the Prosecution of Offences Act 1985, which you mentioned in passing 10 minutes ago or so. Is the short point this, that the statute, the originating statute itself, draws a distinction, and a clear one, between the investigative role of the police on the one hand, and other investigative agencies like the National Crime Agency on the one hand, and the prosecutorial role of the CPS on the other?
Yes.
And if we go over the page, please, to paragraph 49, that distinction is drawn out and emphasised in a document called Police and CPS Relations, which you refer to and quote from in paragraph 49. Is that right?
Yes.
And so we've had the statute so far, this guidance document on police and CPS relations, secondly. And if we go forwards, please, to page 25, at paragraph 50, you say, similarly, section 3 of the present edition of the Code for Crown Prosecutors, issued in October 2018, addresses decisions whether to prosecute, and again makes the distinction between the roles of investigative authorities, such as the police in relation to investigations on the one hand, and that of the director in relation to prosecutions on the other. And then you cite from it.
Yes.
Is that something that was unique to the 2018 8th edition iteration, or is that separation of functions that was something that was ingrained right from the beginning?
Right from the beginning. Different wording, but the essential point and essential importance of that independence was always there.
As you recognise in your report, Parliament expressly permits prosecutions to be brought by private prosecutors.
Yes.
And in the legislation that permits that, it doesn't require them to have this separation. This separation.
Yes.
Are you aware of the reports of the Phillips Commission, which considered private prosecutions?
Yes.
And is this right, that the Phillips Commission considered but did not recommend that the CPS should take on responsibility of prosecutions brought by non-police agencies and private individuals and corporations?
That's right.
Given that Parliament required expressly separation between the police investigative function and the CPS prosecutorial function, but declined to require it in the case of private prosecutors, why do you consider that the Post Office as a private prosecutor is obliged to maintain an inbuilt separation of functions in the same way as the police and the CPS do?
Neither the Phillips Committee nor the Prosecution of Offences Act allowed private prosecutors to have merged functions. They didn't address that, but that was already addressed in cases that we have already passed along the way. For example, I think Maxwell, where it was recognised that private prosecutors nevertheless had to be ministers of justice first and foremost, and that is all about the independence of the prosecutor. And so it was put into statute because it was a statute that was creating a prosecution authority in the majority of cases, but that does not mean that anyone who does not come within the Prosecution of Offences Act was not nevertheless required to have that independence of prosecutorial decisions in place. It was already recognised, and the Act didn't take it away.
Thank you. That document can come down, please. So would this be right? Because the statutory regime is itself a recognition of the fundamental importance of the separation of functions.
Yes. There are different ways it can be done, but that distinction is fundamental.
And therefore it's a recognition, would you say, of the need for separation, the wisdom of doing so, and the consequences of not doing so.
Yes.
And so would this be right from what you've just said? It can't be said that because Parliament hasn't required it, there isn't a need for it to be done.
No, that's right. And in one sense, Parliament has identified the need for it, not just through the Prosecution of Offences Act, but other legislation and codes under legislation that deal with investigative and prosecutorial decision-making, like the CPIA by way of example, all underline that separation of responsibilities. So Parliament has emphasised it rather than taking it away.
On the policies that you have seen, are you able to help us in general terms as to whether the Post Office itself hardwired a separation of decision-making as between investigative functions on the one hand and prosecutorial decision-making on the other in its policies?
It's clear that it had an investigative department and a criminal law department. The latter was the department that would advise on prosecutions. The former was the department that would undertake investigations. And so to that extent, there were those two separate entities. My concern was that in relation to the supervision of those and the ultimate decision-making as to prosecutions flowing from those, there wasn't necessarily that clear separation, so that the same person could be making decisions as to prosecution who was also supervising investigations.
And on what you've read so far of the Volume 2 material, if I can call it that, are you able to help us as to whether, in fact, the Post Office did enforce any separation of decision-making?
Because in the material that I've seen for the purposes of Volume 2, it has not been entirely clear to me who made the decisions to prosecute. I can't there see a delineation of investigative and prosecuting decisions that I couldn't find in the policies.
Thank you. And what about picking another organisation, say the Health and Safety Executive? Have you experience of delineation or separation of functions within the Health and Safety Executive?
And so, for example, the Health and Safety Executive, certainly since 2011, which was as early as I was able to trace things via their website, had approval officers who had a role in relation to prosecutorial decisions who were independent of the investigation. And so that was a built-in filter of independence into the process in a much more clearly defined way than I could find in comparable Post Office policy.
Thank you. Can we turn then to the Post Office policies on this issue? In several parts of your report, in particular paragraphs 30 and 55, you're critical of what you regard as a lack of proper policy guidance as to the need for a division of responsibility between investigators and decision makers in relation, in particular, to a decision to charge. Can we look, please, at page 27 of your report, at paragraph 55? And from this, I'll just wait for it to come up. Paragraph 55, thank you. From this paragraph, A, right through to J, you analyse a series of Post Office policies and guidance materials
Yes.
concerning investigation and prosecution, and analyse whether there is a proper policy guidance within them on the division of responsibilities. Is that right?
Yes.
So if we turn and look at paragraph 55A, and you refer there to the March 2000 investigation and prosecution policy, and you say that it identifies that investigations will be undertaken by the Security and Investigation Service, SIS, or the Business Security and Investigation Unit, whilst it refers to prosecutorial decisions, which it says will be taken in consultation by with the SIS and Legal Services Criminal Law Division. It does not spell out by whom they are to be taken. It does not indicate the standards to be applied or who is to ensure these standards are applied correctly. I think footnote 34 tells us that the 2002 revision of the investigation and prosecution policy is in the same terms.
Yes.
So there are a collection of problems, is this right, that you identify with that policy. Firstly, it doesn't clearly state who will take decisions to prosecute.
Yes.
Secondly, it does not state the standards that are to be applied, whoever that person is taking the decision.
No, that's right.
And thirdly, it doesn't state who is to ensure that the standards are being applied correctly.
Yes, so it doesn't identify either the decision maker or the person who is there to supervise or audit the decision-making process.
A slightly later policy than the March 2000 one, called the Post Office Rules and Standards Policies of October 2000, identifies that investigators are to maintain the highest standards of professionalism without seeking to define them in any detail.
Yeah, that's right.
What's the problem with that, saying you're to maintain the highest standards of professionalism, full stop?
Two people's versions of what the highest unspecified standards are may well be different, and one may be more exacting than another, and in fact neither of them may be right.
Can we look at paragraph 55B, please? You say that the Royal Mail Group Limited Criminal Investigation and Prosecution Policy in its December 2007 version states at 3.1.4, quote, the conduct, course and progress of an investigation will be a matter for the investigators as long as it's within the law, rules and priorities of the business. Investigators will ultimately report to the Director of Security with regard to the conduct of a criminal investigation. The investigators are defined at paragraph 313. RMG security investigation teams are the providers of in-house investigations and will maintain the lead in dealing with the police. In relation to prosecutions at 329, it states, quote, decisions to prosecute in non-CPS cases will be taken by nominated representatives in the business with consideration to the advice provided by RMG criminal law team. The policy remained unchanged in each of these respects in its November 2010 iteration. So the two issues that you identify as potentially problematic within that December 2007 version of the policy, you tell us by your footnote 37, remained unchanged in the 2010 iteration. Yes?
Yes.
Can we look, please, at the policy to which you're referring to? This is Pol 0010-4812. This is the December 2007 version of the policy. And if we just scroll through it, we'll see how long it is. I think it's 3 pages, isn't it? And scroll down. And keep going. And keep going. Thank you. That's the end of it. Okay, so back to page 1 of the policy. And if we just look at, I'm not going to do this with every policy. I just want to pick some examples to see where you've cited from the policy, quoted from the policy, what the policy in fact looks like to get a bit more context. 3.1.3, if we can scroll down, please. Policing crime, this is something you cite. Royal Mail Group security investigation teams are the providers of in-house investigations and will maintain the lead in all dealings with the police. And so that's essentially narrative, isn't it?
Yes.
And then if we go to 3.1.4, the conduct, course and progress of an investigation will be a matter for the investigators, as long as it's within the law, rules and priorities for the business. What's wrong with that?
My concern about that is the lack of specificity about each of those, as long as it's within the undefined law, the undefined rules and the unspecified priorities of the business, and without identification as to which of those trumps which.
And so what are the potential issues which arise?
Inconsistency of application. And what one could read that, not least because if one looks further up the policy box and the first 2 policy objectives at 3.1.1 of protecting the integrity of the mail and 3.1.2 of protecting the business, that protecting the business is the most important. And whilst that may not be the intention, if it's not spelt out with necessary guidance as to what it's talking about, there's the risk of it going wrong.
And so a reader could read priorities of the business as being those priorities identified in 3.1.1 and 3.1.2.
Yeah.
And so what's missing from that sentence? Investigations are a matter for investigators as long as they're within the law, rules and priorities of the business.
If it spelt out there the Post Office policy that they were to apply, which itself identified the relevant statutes, the relevant codes under statute, the relevant guidance from the Attorney General and so on, then the reader would know exactly what it was talking about and what the standards were. Where it doesn't spell those out, there's the risk that important areas of the law and the rules will be missed.
And so the reader doesn't know which law,
No.
which rules, what priorities. Are you advocating, or are you saying that it should all be stated in here, or could be done by cross-reference?
It could be done by cross-reference.
And then if we go to page 3, please. And look at 3.2.9 at the foot of the page. I should read 3.2.8 first. Investigations leading to potential prosecution will be reported in accordance with the CPIA and the CPIA Code of Practice. What do you understand that to mean, that investigations will be reported?
I have to confess it's not altogether clear to me what that means in the context of reporting investigations. That the CPIA addresses aspects of the investigation and aspects of the disclosure regime. The code addresses those areas and also the interaction of investigators and prosecutors. So it may relate to that, but if it set out which parts of the code and the Act it had in mind, then we would know.
So is this one of the examples that we spoke about earlier, where there is a flashing reference to an Act, but it doesn't say in any meaningful sense what's to be done?
Yes. And it could either here refer to the relevant parts, or it could refer to a policy where those parts are identified. So if there was a policy that addressed the way in which investigations were to be reported to prosecutors, and the parts of those that Act and that code that applied in that context, then that would do the job.
And if we can look, please, at 3.2.9, prosecution. Suspect offenders will be prosecuted where there's sufficient evidence and it's in the public interest in accordance with the Code for Crown Prosecutors. Decisions to prosecute in non-Crown Prosecution Service cases will be taken by the nominated representatives in the business with consideration to the advice provided by the Royal Mail Group Criminal Law Team. Two questions there. What, if anything, is wrong with that, and what, if anything, is missing?
This, I think I'm right in saying, in 2007 was the first policy reference in the Post Office policies I had seen to the Code for Crown Prosecutors as being the test to be applied. It doesn't actually reflect that test in referring to sufficient evidence rather than a realistic prospect of conviction. It then refers to decisions on prosecutions being taken by a nominated representatives in the business with consideration to advice, but it doesn't make clear how that consideration is to work. On the face of this, the nominated representative could have obtained advice from the criminal law team and ignore it, in the sense that they could come to a contrary view to the one expressed in the advice that they'd received, as long as they'd obtained it.
So in relation to the first concern, that there's a cross-reference to the Code for Crown Prosecutors for the first time, so far as you've been able to see,
yes,
in December 2007, so well into our relevant period. What's wrong with a policy saying you're to take decisions in accordance with the Code for Crown Prosecution?
Well, firstly, going back to an earlier question, if those decisions are to be taken in relation to a fairly defined range of possible scenarios, there would be sense in your policy addressing those scenarios and how decisions to prosecute should be taken in those situations, rather than referring to a code that is broader than that. Secondly, if the nominated representative in the business is making the decision and they may not be a lawyer, then they need help as to how to apply the Code for Crown Prosecutors, what factors in it they need to focus on, how they interact with each other. And so just being told there is a code that will be applied may not be enough. It depends on who the nominated representatives are, how they are trained, how they are otherwise instructed beyond the scope of this paragraph. But this paragraph on its own doesn't make it clear.
And reading on to 3.2.10 under the heading Conduct and Oversight of Investigations, the policy tells us that Royal Mail Group security employees perform a vital role on behalf of the public, the criminal justice system, and Royal Mail Group limited customers and employees. These stakeholders must have absolute confidence in the integrity, conduct, and professional status of investigators. This means adherence to the laws, regulations, and codes, along with their respective procedure and standards referred to above. What's wrong with that, if anything?
Clearly, that is an entirely correct observation, that is what stakeholders should have an absolute confidence in. Whether this document and the references it makes at this point to earlier parts of the document is sufficient to ensure that is a separate question.
And so overall, looking at this policy document, your principal criticisms is this right, or as follows: it doesn't say who's in fact going to take a decision to prosecute.
No.
It doesn't explain the standards to be applied, and it doesn't explain how those standards are going to be measured or audited to ensure that they're being applied correctly.
And it doesn't identify, in addition to those, how legal advice is to interplay into that process.
Thank you. Can we go back to your report, please, at page 27. I'm going to go through the rest of B to J in your examination of the policies, but without, on each occasion, going back to the source.
Yes.
You tell us, and I think we've got time to fit this in just before lunch, at your subparagraph B, if we scroll down, please. The RMG Limited Criminal Investigation and Prosecution Policy.
That's the one we just
Yes,
looked at, I think.
quite right, over the page to C, thank you, at 28. Moving forward to April 2010, the Post Office Limited Security Policy, hyphen Fraud and Investigation Policy, identifies the fraud investigation team as being in-house investigators answerable to the head of security in relation to prosecutions. At paragraph 3.15, it states, quote, decisions to prosecute will be taken by nominated representatives in the business with consideration to the advice provided by the Royal Mail Group criminal law team, and where there is sufficient evidence and it is in the public interest. Is there any difficulty with that?
In this context, unlike the previous document, there isn't a reference to the Code for Crown Prosecutors, and therefore no clear indication as to how evidential sufficiency or the public interest are to be assessed, providing those two boxes are ticked. And again, my concern, which may be over-exacting, but it is my concern, that consideration to the advice provided by lawyers could be interpreted as long as you've got it, you don't have to follow it.
And so the principal problem is this, right? If problem it is that whereas 3 years previously there had been at least a reference to the Code for Crown Prosecutors, that seems to have evaporated.
Certainly in this particular document, it wasn't there.
And so would a person taking a decision by reference to this policy in April 2010 know that they got to apply the code or not?
It would depend on what they were reading beyond this. If this was all that they were applying, then there's clearly the risk that they wouldn't apply the code. If they were looking at a wider pool of policy instruction and or training, then they might extract it from that, but they certainly wouldn't get it from this.
And it doesn't say what sufficient evidence means,
No.
Nor give guidance on how to ascertain it,
Right.
Nor explain what the public interest means.
And as we'll see when we look at the code in its various iterations in due course, neither of those is a one-line situation. There are a whole range of factors that are identified as being relevant to the assessment of evidential sufficiency, and an even larger range of factors that are relevant to the assessment of the public interest. They're not straightforward questions.
On that note, it's 1 o'clock, so would that be an appropriate moment to break until 2 p.m?
Yes, of course. Thanks very much.
Thank you very much, sir.